Templates and software. In the modern world, various websites are offering different contract templates, either free or for a price. Given the variety of contracts that businesses use, these sites can be useful, but there is no guarantee that the templates will cover all issues that need to be addressed. Still, they can be a good starting point to get an idea. Templates are also found in contract management software and systems. Systems and software offer more than blank templates. They can also provide information on clauses and other legal information to guide the process. Additionally, the process will create standardized formats that will make issuing contracts in the future easier. Compliance. When creating contracts, you must remain in compliance with federal, state, and local laws, and the instructions for remaining in compliance with the contract requirement need to be clear for the chosen bidder. The different sections and clauses should spell out everything and ensure compliance on all fronts. The opening clause will provide the information necessary to identify involved parties and their relationship. The governing law clause will determine which laws apply. For example, a contract in New York will probably be governed by the laws of New York. New York state laws will govern all aspects of the contract, even if the bidder is out of state. Any illegal action will void the contract, so you and your bidder need be aware. If, for instance, a city does not permit the sale of alcohol, a contract with a bartender is not in compliance. One way to prevent confusion is to outline compliant requirements in the consideration. A similar clause is the jurisdiction clause. This clause determines which court will have a jurisdiction should a lawsuit develop. An alternative is an arbitration clause, directing the terms for arbitration in disputes. Wording. Wording is extraordinarily important in contracts. Contracts need to be written in good faith, which is a sincere intent to act justly in the relationship. Additionally, contracts should use the language that is specific, brief, and understandable. While failing to understand a contract does not negate its legality, it can create problems and misunderstandings. Templates, software, and lawyers can assist in creating properly worded contracts. The business and scope of the project will determine which clauses are necessary, but the information needs to be clear and accurate. The obligations of each party should be included. For example, the contract could say, the first party covenants and agrees that it will provide the following. The governing law clause might read, this agreement will be governed according to the laws of New York. Other clauses include, arbitration binds the parties to abide by the ruling of a third-party arbiter in dispute. Example, all claims, disputes, and controversies will be submitted to binding arbitration according to the rules of blank. Integration and merger prevents parties from arguing that oral agreements invalidate the contract. Example, this agreement can only be amended in writing. Ethical behaviors may be further defined by the state and industry. Government contracts, for example, have strict requirements. It is wise for business to have a clear code of ethics for employees and partners to follow. Risks of noncompliance. Noncompliance has its risks for all parties involved. Failure to create contracts that are compliant with the laws governing them can void contracts and create other legal pitfalls. Additionally, any vendors who violate laws because of unclear contract terms will have their actions reflect back on the company. It is possible for the company to be cited for violations of vendors, which is why the contract management is so important. If a company suffers legal or operational consequences due to the noncompliance, the reputation of the organization is also at risk. As the company's reputation suffers, so will the bottom line.